Hello everyone and welcome to HR Options webinar series. My name is Nunzio Presta and I'm responsible for sales operations and marketing for HR Options Canada. It is my pleasure to be your moderator for today's session. Today we will be learning about Canadian employment law and how it is different from the USA. Our speakers will get the webinar started with an overview of Canadian payroll taxes and remittances, an overview of key employment standards across the provinces. They will also discuss Canadian public health care and employer-sponsored group benefits, along with terminations and layoffs in a country without at-will employment. Then we will open it up for a Q&A session. Before I do my introductions, I want to review the features for our online meeting room. You'll notice several windows open on your console, including the Q&A window. All windows can be minimized, expanded, and or moved. We welcome you to submit questions throughout the session by typing a question in the box and hitting submit. Lastly, you'll see a red widget at the bottom of your screen for an evaluation of the webinar that I'll be asking you to complete at the end of the session. If you have to leave early, please take a moment to complete the survey before you close out. I also want to notify everyone that we will be live tweeting during the webinar as well. The hashtag is #HRO webinar series. Feel free to engage. Now let me introduce you to my colleagues Kathryn Benson and Stacy Glass, who are both highly experienced senior human resource consultants with HR Options. Stacy and Kathryn have both worked with a wide array of companies, and their area of expertise at HR Options include ensuring clients are compliant with employment laws across Canada, as well as payrolling, recruiting, training, employee relations, and HR policy development. At HR Options, we provide HR consulting and payrolling services throughout the U.S. and Canada, and we have been doing this for over 25 years. If your organization is new to employment in Canada, HR Options can provide HR support, or if you are not ready to take on the Canadian employment role, let us be your employer for your company throughout Canada. So it'd be your workers on our payroll. It's always nice to have options, and that's what HR Options is all about. Today's webinar will be recorded and posted on HR Options website. Also, please feel free to reach out to the speakers for more information after the webinar is over. They would love to hear from you. And with that said, I'll pass you over to Kathryn, who will begin today's broadcast with a short introduction. Thank you.
Great. Thank you so much, Nunzio. So hello, everyone, and thank you again for attending today's webcast on a crash course in Canadian legislation. It's one of our most popular and highly requested webinar topics. So as Nunzio said, today we'll be covering topics that are frequently asked about. So if you do have other areas of interest that we're not covering today, please feel free to reach out to us directly. Today we will be discussing employer payroll taxes and remittances, key employment standards including vacation and other leaves, drug and alcohol testing in Canada, public health care versus employer-sponsored benefit plans, how to end an employment relationship in Canada, and lastly some employment options for you in Canada. So let's get started. So to start off, many new employers to Canada that we've worked with have mistakenly thought that they are federally regulated by the Canada Labour Code. In fact, only 10% of industries in Canada fall under federal legislation. So I wanted to briefly cover what is governed by provincial versus the federal government. So each province has control over employment standards legislation, so things such as minimum wage, vacation pay and leave, workers' compensation boards and health and safety, and lastly over human rights. Whereas the federal government has control over employment insurance programs, with the exception of Quebec, who administers their own EI program, and for specific industries only, such as banks, air and marine, transportation, and telecommunications, the federal government legislates employment standards through the Canada Labour Code and administers workers' compensation and health and safety regulations. Most of you listening today should refer to the provincial regulations where your employees work. The rest of today's webcast will apply to provincially regulated companies, as again, 90% of companies in Canada are governed provincially. And it is important to note that each province, like each state, has its own interpretation and laws for employment standards. So now that we're all on the same page in terms of jurisdiction, let's turn to payroll taxes and remittances. So first of all, to set up in Canada as an employer, you'll need to obtain a business number from the Canada Revenue Agency, known as the CRA, and register for a payroll and sales tax account. And you'll need to register with the Provincial Workers' Compensation Board where your employees are working. Once you start to pay your Canadian employees, the payments to be remitted to the CRA, the Canada Revenue Agency, include your employer-paid portion of the Canadian Pension Plan, called CPP, which is 4.95% of the employee's salary. You'll pay the employee-paid portion of the CPP to the government as well. They pay the same amount. You'll also remit the employer-paid portion of employment insurance, called EI, to Service Canada, which is 2.632% of the employee's salary. And, of course, you'll remit the employee-paid portion of EI as well, which is a bit lower at 1.88%. And all of these percentages that I've mentioned represent 2015 rates. And of course, you'll remit employee-paid federal and provincial income taxes to the CRA as well. Some provinces also charge an employer-paid and an employee-paid health tax, such as in Ontario, which I'll delve into on the next slide. But before I get into that, lastly, remember that an employee's income and deductions are reported on a T4 at year-end, which is similar to the W-2 in the U.S. So to look more in depth at the health tax I just referred to, I'll review 3 provincial scenarios where employer-paid health tax is currently applicable. So in Ontario, if your annual payroll dollars in Ontario exceed $450,000, you have to remit 1.95% of payroll in employer health tax, known as the EHT. If your payroll in Ontario is less than $450,000, your contribution rate will be scaled down. The lowest rate is 0.98% for $200,000 or under in Ontario payroll. And we do have a handout on the resource section of the platform today called Statutory Laws Across Canada, which provides links to each province where you can get more information. In Quebec, if your annual worldwide payroll dollars, and this is a big distinction, exceeds $1 million, you must remit 2.7% of payroll to the Health Services Fund known as HSF. If your annual worldwide payroll dollars exceed $5 million, you have to remit 4.26% in HSF of the employee's payroll. And again, follow the handout links for more information. Lastly, Manitoba has a health and post-secondary education tax levy known as the HE levy, where you only pay if you have a payroll in Manitoba of $1.25 million. And in this case, you pay 4.3% of the amount of payroll in excess of the $1.25 million. If your payroll exceeds $2.5 million, you have to remit 2.15% of your total payroll. And here, the $1.25 million exemption does not apply. A last note here is that Alberta was going to introduce a health tax effective July 1st of this year, but that was repealed. So just a heads up that may be reintroduced in the future. So before we move past employer statutory tax remittances, I wanted to highlight again that in Quebec, they administer their own pension and employment insurance programs, unlike the rest of Canada, where pensions and EI are federally regulated. In Quebec, the employee and employer-paid portion of the Quebec pension plan is 5.25% versus the 4.95% that we saw on the earlier slide for the rest of Canada. For employment insurance, the employer-paid portion of employment insurance is 2.156%, and the employee-paid portion is 1.54%. On top of this, Quebec also has the Quebec Parental Insurance Plan, called QPIP, where the employer-paid portion is 0.782% of payroll, and the employee-paid portion is a bit less at 0.559% of payroll. So as you can see, Quebec breaks employment insurance into regular EI and parental EI for an overall higher rate than the rest of Canada. But, as we'll see later, Quebec parents also get up to 70 weeks of maternity and parental leave versus the 52 weeks in the rest of Canada. My last note on this slide is to recap again that in Quebec, employee income and deductions are reported on a T4, but they're also reported on a relevé at year-end. So next, an important tax to consider if you're doing business in Canada is the Goods and Services Sales Tax. This may apply when you sell your services in Canada or when you use a Canadian vendor who is selling you services or products. The federally regulated goods and services tax, known as the GST, is set at 5%, and then each province regulates provincial sales and services taxes that may be charged on top of the 5% GST. Some provinces, such as Ontario and Nova Scotia, have quote-unquote harmonized the federal and provincial sales tax into one lump sum called the HST, while other provinces have maintained a separate system for the federal GST and their provincial portion of the sales tax. So I won't go through each example that I've listed on this slide, since this topic is an entire webcast in itself, but I wanted to just give you a heads up to speak with a financial advisor regarding how the GST, PST, or HST will impact your business in Canada. An experienced accountant can help you look at zero rating categories, meaning you can be exempted from charging or being charged sales tax by your Canadian vendors under certain conditions. So in this case, in order to be zero rated, you must be considered a non-resident under Canada's Excise Tax Act, meaning you have no permanent establishment in Canada, so no fixed place of business, including a place of management, a branch, an office, or a workshop, or any place of extraction of natural resources. However, you can have an independent agent acting on your behalf in Canada. So for example, if you want to hire a Canadian employee to work from a Canadian home office, you can use the services of an outsourced employer, such as HR Options, without it affecting your non-residency status. Again, I'm happy to refer anyone interested in this topic to a Canadian tax expert if you want to contact me after today's webcast. And with that, I'm going to pass it over to Stacy, who's going to begin our talk on how to pay your employees in accordance with employment standards legislation in Canada.
Great. Thank you, Kathryn. Provincial employment standards legislation covers everything from minimum wage to termination requirements. And what I'd like to talk about now is overtime rules, which, like most employment standards, vary per province. So throughout the webinar, we're going to give you examples from across Canada to highlight some of those differences. However, you have to be sure to investigate what applies to your employees by going to the provincial websites where your employees are working. So for provincial specific links, as Kathryn mentioned, we do have that great resource on our page called Statutory Laws Across Canada that can help you locate what you're looking for in each of those provinces. And generally, the overtime rule is 1.5 times the employee's hourly wage for hours in excess of the weekly or daily maximums. So for example, hours worked in excess of 40 hours per week would be considered overtime in BC and Quebec, 44 in Alberta and Ontario, and anything over 48 in Nova Scotia. And note that Alberta also has daily maximum of 8 hours as well as the weekly maximum of 44 hours. So you pay overtime on whichever amount weekly or daily is a greater benefit to the employee. If the employee is paid via incentive pay, so piecework or commission, minimum wage is used to determine overtime pay. Just note that the definition of wages also varies per province when determining the rate of overtime. Some may include vacation pay for overtime and others don't, so be aware of what province your employees are in. There's not enough time for me to go over it today, but I'd like you to be aware that there are options if you do require a lot of overtime. You could implement an averaging agreement, or you could develop agreements with employees to take overtime off as banked time. So there are other options to paying out overtime if you have a lot of overtime for your employees and, of course, that your employees agree to those terms. In all provinces, overtime applies to full-time, part-time, and student employees, interns or otherwise. An employee is an employee is an employee. And overtime is also applicable whether the employee is paid hourly or salary. And in Canada, we don't regularly use the terms exempt versus non-exempt like in the U.S., but rather most employees are eligible for overtime pay even if they're salaried. The only reason someone wouldn't receive overtime pay is if they meet specific exemptions. So for example, an employee whose job duties qualify them as true managers wouldn't qualify for overtime in Ontario and in most other provinces. Exemptions from certain employment standards in Canada are based on what the employee is actually doing, so their duties, and not necessarily by their title. And in New Brunswick, there's actually no exemptions, so keep that in mind if you have any employees there. I've added some links to this slide for your reference to some special exemption rules to determine if your employees would be considered exempt. If you have employees in another province that's not listed, feel free to reach out to us for more information. In Ontario and Quebec, overtime does apply to travel hours. All work hours, even travel hours, fall under normal hours of work regulations where those exemptions that I spoke about earlier don't apply. Also, in Ontario, commuting time and travel during the workday are treated differently under the Employment Standards Act. Commuting time is the time it takes an employee to get to work from home and vice versa. This is not counted as work time for the purposes of the Employment Standards Act. However, there are a number of exceptions to this rule. So for example, if the employee takes a work vehicle home in the evening at the employer's request, work time begins when the employee leaves home in the morning and ends when he or she arrives home in the evening. Also, if the employee is required to transport other staff or supplies to or from the workplace or work site, that time must be counted as work time as well. So next, if the employee has a usual workplace but is required to travel to another location to perform work, the time traveling to and from that other location is counted as work time in both Ontario and Quebec and in most other provinces. So be careful to check regulations again for employees exempt from overtime regulations, like those managers. They're probably eligible to be paid for travel hours, but the overtime calculations just don't apply. So again, refer to today's handout for any specific rules that apply to your employees. Next, this slide is on public holidays. It does have a lot of information on it, and it's really meant to be a reference for you after today's webcast. Firstly, all statutory or public holidays listed on this slide must be paid to employees under the Employment Standard Act of each province. For each holiday, the slide shows which provinces mandate that you pay for the holiday. However, there are cultural norms and special rules, and some of which I've noted directly on the slide that you'll see, and some that I'll just highlight for you. So for cultural reasons, many employers have designated additional holidays not listed in the provincial employment standards. For example, Boxing Day, which is the day after Christmas, and the August civic holiday are not official statutory holidays in some provinces, but many companies provide that as a paid day off for employees. Also in Quebec, January 2nd is usually provided as a holiday as well, just culturally, not in the law. So keep in mind, though, if you do choose to honor one of those extra days as an additional day for employees, despite the extra day not being officially listed in the employment standards, all rules pertaining to that general holiday, pay will apply to that day if you do deem it as a holiday for your employees. So be aware of that. To expand for just a moment on a special day in Quebec for anyone who's looking to come to Quebec or has employees there, Saint Jean-Baptiste Day on June 24th in Quebec is a special holiday because it's only celebrated in Quebec and has special provisions, including that almost all employees have the right to this holiday, or at least to compensation. So even if they are not covered by the Act respecting labor standards in Quebec, so let's say they're exempt, and also if an employee has to work on June 24th and you offer the employee a replacement holiday to compensate him or her, that replacement holiday must be taken the working day before or after June 24th, and for the rest of the holidays within 3 weeks before or after that holiday in Quebec. If you don't offer a replacement holiday, you must pay that holiday pay to that employee for Saint Jean-Baptiste Day. And in regards to payment of holidays, again, it does vary per province, but if an employee agrees to work on the public holiday, and in some provinces they have to agree in writing, you generally have to pay them for that day worked and premium pay for another full day and a half. So for example, an 8-hour day employee would get 8 hours for the day worked on the public holiday, another 1.5 times that day, so another 8 plus 4 hours for a total of 20 hours for that day. Alternatively, with the employee consent, you can provide them with another substitute day off work in lieu of the holiday. So in terms of who's eligible for paid public holidays, most provinces will list a time period that an employee must have been employed before being eligible for the holiday pay. So for example, in Alberta, the employee must have worked for the employer for at least 30 working days in the year before the general holiday. In BC and Nova Scotia, for example, the employee must have worked 30 calendar days before the holiday and have worked or earned wages in 15 of those 30 days before the holiday. Whereas in Ontario and Quebec, it doesn't matter how long the employee has been with the company. They're entitled to the holiday, but the pay is prorated by taking their hours worked in the last 4 weeks and dividing them by 20 to get the holiday hours owed to them. Many provinces, including Ontario, say the employee must have worked their last scheduled shift before and their first scheduled shift after the holiday in order to be paid for the holiday. But a word of caution here is just be aware that the employee will remain eligible if they have the employer's or your permission to be absent for either or both of those shifts. So for example, because of an approved vacation or legitimate sick time. And lastly, to qualify for holiday pay in most provinces, the employee must not have refused to work on the general holiday when they were asked to do so. And some common jobs that are exempt from holiday pay include agricultural workers, managers, some commissioned salespeople. But again, we have kind of a theme throughout our webinar today. Check your province using the link that we provided and the proper websites for the province to make sure that you're paying holiday correctly. And now I'm going to pass things back to Kathryn to review vacation pay.
Great, thanks, Stacy. So the most important thing to remember in terms of vacation is that vacation time and pay applies to salaried, hourly, full-time, part-time, student, and contract employees. Vacation normally starts at 4% of gross earnings, or 2 weeks per year for a full-time person. Some provinces will legislate mandatory increases in vacation, as I've listed on the current slide. Note that in Ontario, Ontario never legislates an increase to 6% or 3 weeks per year, but the norm is for many professional positions to start at 3 weeks per year. So please keep this in mind when recruiting if you want to stay competitive. So how vacation is paid can often be a source of confusion to companies new to Canada. Even companies not new to Canada, it can be confusing. Vacation rules and exemptions vary per province, but to highlight a common example, I'll use Ontario, whose legislation is comparable to the other provinces. In Ontario, the legislation covers vacation time and vacation pay. So for vacation time, employees are entitled to 2 weeks time off after 12 months of work, but keep in mind that the norm is to allow time to be used as it is accrued for many positions. In addition to that time off, employees are entitled to at least 4% of their gross wages earned in the last 12 months paid as vacation pay. It's important to note that gross wages may include regular pay, bonuses, public holiday pay, commissions, overtime, termination pay, etc. So again, check with your provinces, check which province your employees are in to determine the definition of gross wages. So at least 4% vacation should be paid on all these types of compensation that I just listed. So it's a normal practice to pay the employees through their vacation as well as to pay their 4% on any additional payments, such as bonuses and commissions, at the time of payment. So you know that by year end, you've met all the legislation. And lastly, remember that you must pay out all accrued vacation to a terminated employee up to and including their last day of work. Next, we often get asked if it's normal in Canada to allow employees to fall into a negative vacation accrual. So for example, if an employee has only worked for 6 months, but asked for their full 2 weeks of vacation time off, in this case, the employee would fall 1 week into the negative and not, quote-unquote, climb their way out of a negative accrual until year end. In truth, for professional level positions, many employers allow negative accruals and trust that the employee's accrued time will balance out. But if you have high turnover, I would definitely not recommend allowing negative accruals, since it's normally never allowed in Canada to deduct any funds from an employee's pay, including negative vacation accruals. A practical solution is to implement a negative accrual cap. So for example, your policy can state that with management approval, and if it doesn't interfere with workflow, employees are entitled to fall into a negative vacation accrual of no more than 5 days before vacation requests will be denied until vacation days are accumulated. So that's one small example of how you can word it. To answer another common question, you can carry vacation accruals to a new year, and you can cap vacation accruals so long as the cap doesn't interfere with the employee receiving their minimum vacation entitlements under employment standards laws, or whatever is written into the employee's contract. Lastly, it's important to know that employees on unpaid protected leaves of absence, so things such as sick and maternity leave, the employees will continue to accrue seniority and unpaid vacation time. However, they will not be entitled to vacation pay for that time on unpaid leave. For your vacation policies here, it's very important to be very careful how you word your vacation policy and how you outline vacation pay in your employment agreements. If you indicate that employees are entitled to a flat 2 weeks paid vacation each year and you fail to link vacation pay to their accrued earnings, you may have an employee on a long-term leave asking for their 2 weeks paid vacation despite the fact that they have no earnings and they would be entitled to that pay. Now we're going to shift gears a little, and I'm going to take you through job-protected leaves of absence in Canada. So when I say job-protected leaves, I mean eligible leaves that fall under human rights or employment standards legislation that an employer must allow an employee to take. However, the employer is not required to pay the employees throughout these protected leaves. So this slide highlights some protected leaves for your reference, but I'll specifically be reviewing with you today pregnancy and parental leave and compassionate care leave. Before I get into my specific examples, human rights legislation gives specific rights to employees on protected leaves that I wanted to make sure to highlight. So first is the right to reinstatement after their leave to the same job or comparable job if that same job no longer exists, and the right to the same pay or increased pay if it went up while the employee was on leave. 2, employees have the right to be free from penalty or discrimination from the employer for taking the leave. And 3, they have the right to continue to participate in benefit plans while on the leave. So for example, pension, life insurance, or extended health and dental plans. The first leave I'll review with you is pregnancy leave, which I know surprises a lot of our U.S. listeners when we cover this topic. And as usual, the leave legislation varies per province, and in this case, Quebec is the most generous. In general, pregnant mothers can take between 15 and 18 weeks unpaid pregnancy leave, and on top of this, 35 to 37 weeks unpaid parental leave, so generally 52 weeks total. However, in Quebec, mothers can take up to 52 weeks unpaid parental leave on top of the pregnancy leave. Fathers and adoptive parents are not left out, and guardians, they don't get to 15 to 18 weeks pregnancy leave, but they can take up to 37 weeks unpaid parental leave. And again, in Quebec, this parental leave is the most generous and can extend to 52 weeks. Quebec also grants fathers 5 weeks unpaid paternity leave on top of the parental leave. So how do you qualify? To qualify, employees must be covered by employment standards legislation, which 99% of you who are listening today qualify under. An example of an employer exempt from employment standards would be law firms, for example, who are self-regulated. Also, to qualify, generally an employee has to be hired at least 13 weeks before the start of the leave. But in Alberta, be careful because it's 52 weeks. However, please note that the employee doesn't have to actively work the 13 or 52 weeks before the start of the leave. They can be off on sick time, and this counts as active work. A final note of interest here is that since the leave is not paid by the employer, employees taking this leave receive employment insurance benefits from the government, which are approximately 55% of the employee's salary to a maximum of about $514 per week for the 52-week period. And again, this formula is a little different in Quebec. Next, the Federal Canada Labour Code and most provinces allow employees to take unpaid job-protected leave for family medical, also known as compassionate care leave. To qualify, the employee must need to care for a specific family member or someone the employee considers to be like family who's at risk of dying in a specified time period. The employee must provide a certificate from a doctor to the company indicating the family member is at risk of passing away in the next 26 weeks. And as usual, as you keep hearing us say, the leave varies per province, but in general, for example, British Columbia, Ontario, and Nova Scotia, for a full-time, part-time, or contract employee, they can take up to 8 unpaid weeks in a 26-week period, and in Quebec, an employee can take 12 weeks in a 12-month period. The 8 to 12 weeks of leave does not have to be taken all in a row, and if illness continues, the employee can reapply for more time. And again, since the leave is unpaid, the employee can apply for government employment insurance benefits, in this case called compassionate care, while they're on leave. Finally, to wrap up my section on leaves, I wanted to throw this in because they're very new in Ontario. Effective last fall, October 29th, 2014, Ontario legislation expanded to include 3 new leaves. So those 3 new leaves are family caregiver leave, which will allow an employee to care for a family member for up to 8 unpaid weeks without the risk of death stipulation under the family medical leave or compassionate care leave. Secondly, critically ill child care leave is for employees that have been employed for at least 6 months consecutively, and they'll be entitled to 37 weeks of unpaid leave to provide care or support to their critically ill child. And third, Ontario now has a crime-related death and child disappearance leave. This is for employees who have been employed for at least 6 consecutive months and are parents to a child who disappeared as a result of a crime. Employees will be entitled to up to 52 weeks of unpaid leave. And where it's probable, considering the circumstances, that an employee's child has died as a result of the crime, the employee will be entitled to 104 weeks of unpaid leave. Hopefully no one ever has to use this leave. But please be aware of these new leaves moving forward if you do have employees in Ontario. And now I'm going to pass it over to Stacy again, and she's going to go through drug and alcohol testing.
Great. Thanks, Kathryn. A topic that is always under debate in Canada, specifically in the northern Alberta sands, where there are a lot of safety issues, is drug testing. And drug and alcohol testing is rare in Canada, and in most cases, it's not worth the legal risk to do them. However, a recent Canadian case did confirm the following scenarios where drug and alcohol testing would be permissible. So firstly, in safety-sensitive positions where an accident or incident has occurred, as part of a post-treatment monitoring program in coordination with the employee, and as a condition of continued employment after a drug and alcohol policy violation has occurred. And finally, and most important is pre-employment testing, meaning prior to the employee's appointment to a safety-sensitive position or pre-access to a safety-sensitive site. So safety-sensitive means being under the influence could cause irreparable damages or death. So the key here is to note that it truly has to be a safety-sensitive position or safety-sensitive site to warrant a pre-employment drug or alcohol test. And the testing would take place after the employment offer has been provided to the employee. In some provinces, it's not the actual tests you administer that are discriminatory. You can do them. It's what's done with the positive result that raises concern for the human rights commissions. Specifically, that you must accommodate for any employee that you test that produces a positive result and is determined to be dependent on alcohol or drugs. So some things you should be doing to ensure that you are not violating employees' rights include having a solid and well-defined drug and alcohol policy in place. So this includes why you have it, who it applies to, how testing will work, what happens in the case of a positive result, employees' right to privacy, definitions, discipline, accommodation, and rehabilitation stipulations. And lay out truly what the employee can expect from the company and the company's expectations of the employee in regards to drugs and alcohol at the workplace. And ensure employees are aware of your policy. It's always good to have employees sign off acknowledgement on your policies on a regular basis. And identify the risks of partaking in drug and alcohol use at the workplace. So for example, list the dangers to employees and their colleagues if they partake in those substances. Also assist however possible to prevent drug and alcohol incidents. So for example, try offering education sessions on those topics. If you're contemplating the adoption of testing as part of a drug and alcohol policy, you will need to take into account that the burden is on you, the employer, to show the courts that the testing is necessary to the job. You should also realize your obligation to demonstrate the reasonableness of the tests, and it's your duty to accommodate employees who fail those tests and are suffering from drug abuse or addiction problems, including alcoholism, to the point of undue hardship. At this point, there's no province which does allow random drug testing where an incident has not already occurred. So in keeping with the medical theme, I'm now going to talk about healthcare benefits. And I often get asked by our U.S. clients why a Canadian employer should provide benefits when Canada has public health care. And the truth is, although some services are covered through provincial governments, many benefits are not. And this may be redundant for our Canadian listeners, but I do want to start us all off on the same page. So each province and territory in Canada has their own public health insurance plan. So for example, in Ontario, it's referred to OHIP. In Quebec, it's RAMQ. And in Alberta, it's Alberta Health and Wellness. So I'll be referring to OHIP today to keep things simple. Each province's health insurance plan covers different medical necessities, but overall they're very similar. As with most health insurance plans, OHIP doesn't cover any services that are not medically necessary. So for example, optional plastic surgery would not be covered. On top of that, public health care also won't cover most prescription medications, dental care, long-term disability, or eye care for most people. Again, there are variations between provinces and variations based on employee circumstances. Generally, the provincial plans will only cover general and specialist doctor visits, government-approved immunizations, and hospital stays, surgeries, and emergency hospital care. So a typical employer-sponsored benefit plan, which is what most Canadian employees would expect if they were to take a job with you, would cover the basic benefits not covered by the province's public health insurance plan. So for example, a typical plan might include medical coverage, so maybe 80 to 90% of prescription drug coverage, a semi-private hospital room instead of ward rooms, and paramedical service like massage therapy or a physiotherapist from about $300 to $500 per year per person on the plan. For dental, usually 80% of coverage for basic dental treatments and 50% for major treatments up to a maximum per year. And competitive plans will also offer vision care, long-term disability, travel coverage, life insurance, and accidental death and dismemberment, which are usually about 2 times the employee's salary. We'd be happy to recommend a great benefit broker if you are looking into a plan or would like to revise or save costs with your current plan. An approximate cost for an employer-sponsored benefit plan would be between about $200 and $250 per month per employee, again, depending on what coverages you choose for your plan. And next, I'll review some benefit policy tips to help with your benefit policy creation. You want to make sure you clearly detail the premium split. So for example, will your premiums be 100% employer paid, or will you split premiums like a 50-50 between your company and the employee? So make sure your carrier is aware of your premium payment method, because most carriers do not allow the employees to pay 100% of the premium. And make sure all policies regarding benefits are made clear to your employees. Put them in your employee handbook so the employee is aware of the policies from the day they start the job. The split in premium can affect taxation, so informing employees about that is very important. Next, be aware that you cannot reduce or eliminate benefits without providing reasonable notice to employees. In my section on termination, I'll talk a little bit about minimum notice requirements, and that can be used as a guide in this scenario. Next, have a clear policy on how long your supplemental health and dental benefits will extend if an employee is off on long-term disability. Typically, Canadian companies will keep employer-sponsored benefits going until the employee starts long-term disability, so about 4 months or 26 weeks. Some employers will also extend for even longer, 24 months or even longer. But without a limit clearly indicated in the employment contract on how long your medical and dental will last for employees on long-term disability, you may be covering them for much longer than you think is reasonable, and you'll have difficulty removing them from your plan. So think about if the employee's doctor says they'll never be able to return to work again, be clear in your contract when health and dental benefits will end for that employee in that scenario. And lastly, for an employee on sick or voluntary leave, you're allowed to pass 100% of the supplemental benefit premium cost to the employee. Again, be sure to include this in your policy upon hire so employees are aware ahead of time what is expected of them. And Kathryn will now talk more about the importance of new hire employment agreements.
Great, so when should you have an employment agreement? We say always. Canadian law assumes that employees retain all rights unless specifically contracted away, which is very different than at-will employment. However, contracts must also provide for entitlement at least equal to the minimum standards under employment legislation. So for example, you can't put in your contract that the employee will earn less than minimum wage. If you did put a lower than standard clause in your agreement, lower than the employment standards, it would make the entire contract void. It's common sense, but I'll say it anyways, as we surprisingly get a lot of people who do it in the wrong order and then get in trouble for it. Always give the contract to the employee and have it signed by the employee prior to them starting the position if you want the agreement to hold up in court if ever challenged. Also, all contracts need to provide clear consideration to the employee in exchange for them entering into the agreement. An example of consideration is that the employee will receive a specific salary and benefits for the work that they will be performing. It's also a great idea to make sure that you're providing updated agreements each time there's any consideration being provided. So for example, if you give the employee a raise, a bonus, a promotion, or another change, and this will keep your contract up to date. Courts will not rely on old contracts from 10 to 15 years prior, especially if any employment conditions have changed since the original contract was signed. Also, always provide a reasonable opportunity for the candidate to review or seek legal advice before they sign the employment agreement. So we usually say somewhere between 3 and 5 days for them to review it before they sign it back to you. So this slide has a list of potential employment agreement clauses you can have in your agreements. Obviously, some are meant for the more senior or executive agreements. And here, as a side note, we've seen a lot of employers putting an end date on a contract. So my recommendation is to only use fixed-term contracts when you truly intend the employee to only work a specific amount of time or on a specific length project. If you do use a fixed-term contract, you must put specific termination language. If you don't and you let the employee go prior to the agreement end date, you'll be on the hook to pay them out until the end date that you listed, sometimes months and months or years of payment. Also, with specific end dates or termination language, you'll want to clearly state that the employee has a duty to mitigate. A better option, if you're unsure of the length of an assignment, is to use an indefinite term contract. So don't put an end date, and just provide the appropriate termination notice should you have to terminate that employee. So there's a lot to consider in regards to compensation in the employment contract as well, but here are a few that often get overlooked. So ensure that you have addressed all direct and indirect forms of compensation, for example, bonus structures, commissions, incentive benefits, vacation, etc. Secondly, consider all compensation as well, so things such as membership dues, association costs, and location costs for moving at the company's request. And how will the entitlements be dealt with upon termination? Clear language must be used to ensure it's understood when exactly rights to entitlements will end when the employee is terminated. For example, final commissions will be paid once invoices are paid, or year-end bonuses will not be paid if you're not employed with the company at year-end, or benefits will cease upon termination, etc. It's important to let employees know upfront what will happen upon termination. Next, I'm going to briefly touch on restrictive covenants. Common law in Canada does recognize the duty of employees to protect and maintain the confidential information belonging to an employer. However, by putting it in your employment agreement, you are explicitly informing employees of their obligation as well as clearly defining what you consider and expect to be treated as confidential material. Non-competition agreements, similar to the U.S., are generally unenforceable in Canada, unless they're super concise in terms of geography and length of enforceability. And the argument for the non-competition agreement is that you're protecting only vital information. You have to have a valid reason for putting a non-compete in place. If it's not specific enough, the courts will see it as a restraint on trade, and it will be unenforceable. So generally, a non-solicitation agreement may be more appropriate. The law in the area of non-solicitation clauses is constantly evolving. Again, the restrictions must be found to be reasonable in terms of length and geographic scope. Ensure that you use appropriate language in your non-solicitation agreement. So for example, use the actual words non-solicitation, because if it looks too much like a non-compete, it will be unenforceable. On a final point, you should never use a blanket restrictive covenant clause. You should always tailor the clause to the nature of the position's job duties being performed by the specific employee in question. As for termination clauses, and just a note that Stacy will be discussing termination shortly, we recommend limiting with specific language the amount of termination pay the employee will be entitled to. So for example, limiting employees specifically to employment standards minimum termination notice to reduce your risk of common law exposure. Outside of Quebec, this language will help limit your financial exposure. You can be creative and add your own termination clauses in regards to a fixed entitlement or a formula based on years of service, again, so long as it goes beyond minimum standards and you ensure to add the duty of the employee to mitigate. Finally, you will want to consider short-term and long-term disability coverage and when those will end. Recent cases have determined that employers are on the hook for long-term disability, or LTD, during notice of termination periods where not stipulated in the employment contract. Make sure you've confirmed with your benefit carrier how long your employee's benefits coverage will last when they're terminated, and adjust your offer of employment accordingly. Other things you should consider in your termination clauses is what happens if the employee resigns. So how much time would you like the employee to give you? Or what will the employee's probation period be? So it's generally 3 months without having to provide notice of termination, but you can provide a longer probation period so long as you, after the 3 months, provide notice of termination. And finally, should you list the circumstances where termination will result without any notice or notice pay, and that's referred to as just cause. And on that note, I will pass it over to Stacy to review the terminations in Canada.
Great. Thank you, Kathryn. So now that we're nearing the end of the webinar, it's a good time to talk about the end of the employment relationship. So I'm going to probably start by surprising a few of our listeners again today by saying that there's no such thing as at-will termination in Canada. Instead, notice of termination must be given to employees, including temporary, contract, and student employees. And as usual, the minimum employment standards do vary per province. So to answer a common question first, when an employee terminates, an employer must provide a written termination letter and a record of employment known as the ROE. The ROE document is regulated by Service Canada, a federal agency, and collects payroll information and the reason for termination details to determine if the employee can qualify for employment insurance. And this document generally has to be provided within 5 days of the termination. So So when you want to terminate an employee, you can choose to provide working notice or pay in lieu of notice. Working notice means that you can tell an employee on a Monday that effective immediately they have 2 weeks of work left before their employment terminates. This is done when there are really no security concerns and they can just work out the notice. Versus pay in lieu of notice, which means that you can tell the employee on a Monday that his or her job is terminated effective immediately, but the employee will get a lump sum payment in lieu of working out that notice. So generally the minimum standard is, but again it depends on the province, that the employee gets about a week worth of notice or a week of salary for each year of service to a maximum of 8 weeks of notice. Also, on top of this, Ontario and in some cases the Federal Canada Labour Code legislate that for employees of certain seniority in Ontario over 5 years, a lump sum severance payment based on the length of service must also be paid on top of the notice pay. So in Ontario, for this to be true, you have to employ more than 50 employees and have a payroll of over $2.5 million in Ontario. So next, when terminating an employee, all outstanding vacation pay must be paid and employee benefits maintained throughout the notice period. Also, as an aside, but I feel it's important to mention, if an employee provides you with 2 weeks' notice that they're quitting, and if you, for security reasons, ask the employee to leave immediately, you're still responsible for paying the employee through their notice and to continue benefits until the end of the notice period, unless you have a clearly worded clause in the employee's offer stating otherwise. And lastly, you can't change any conditions of employment during the termination of notice period. So if they're working out their notice period, you can't decide that because the person is leaving anyway to reduce their hours or their responsibilities. And next, distinct from minimum employment standards legislation, but extremely important when you're determining the appropriate notice to provide a terminating employee, is common law. Common law is based on legal precedent and increases the notice periods that should be given to employees. So for example, for many high-level professional positions, a common law practice may be to provide around a month of notice for every year of service as opposed to a week. However, in Canada, you have to treat every termination as unique and handle it accordingly and as consistently as possible across your company. So tied to common law notice, there are individual characteristics of the particular termination that you're dealing with, which will also affect how much notice to provide. For example, if you're terminating a 59-year-old product specialist who's worked for your company for 30 years, the notice of termination would be most likely well above the month of notice per year of service, since the courts would determine that the employee would have difficulty finding another job due to their age and because their career has been focused on your specialized product, thus making a comparable job quite difficult to find. This employee would need termination pay equivalent to many, many years of service. Overall, when terminating in Canada, you must pay attention to minimum notice standards, common law, and the list of specifics that you're facing. And in many situations, it's wise to get legal advice since common law precedent is changing all the time. I'm sure many of you were waiting to hear this as well, but notice and severance do not apply if the employee is terminated for cause or just cause. So for cause or just cause termination means that just like I said, no notice or severance has to be paid. It occurs when the employment relationship is severed via the employee committing fraud, theft, or willful misconduct. But be cautious, for just cause terminations are very difficult to prove, and you must ensure that you've documented and have concrete reasons for it to hold up in court, and make sure that you have it very well documented. For example, performance problems would be very difficult to justify as a for-cause termination, even if you did have documentation in that case. And overall, it's advisable to have a consultant or lawyer confirm that you're taking the appropriate actions before terminating any employee for cause in Canada. So now that you're more aware of the various legal complications and legislation, I wanted to review some employment options available to you in Canada. One option is to bring your U.S. workers to Canada to work on projects for you, or potentially on a longer-term basis. You can do this through Canada's work permit, or in the U.S. referred to as visa process. Just be aware ahead of time that you will have to set your company up in Canada in order to properly administer the employment taxes for those employees and understand employment standards for the provinces that they'll be working in. Another option, of course, is to hire an independent contractor in Canada, who by definition is self-employed, so this removes any tax deduction remittance responsibility from you. This can be a great solution if the worker is truly an independent contractor. Like in the U.S., if you misclassify the IC and they are an employee, you could be stuck paying all the back taxes and the employee's portion, as well as penalties. And a final employment option is to use an outsourced or third-party employer, such as HR Options. In cases where you have a project to be done in Canada, or you have an amazing employee in the U.S. who's moving to Canada that you wish to retain, or a U.S. employee you want to work in Canada, or maybe you just want to test out the Canadian marketplace with a salesperson, but you don't want the administrative hassles of dealing with the Canadian government, or don't have the time to understand Canadian legislation, a third-party employer can really help you by employing those employees for you. A reputable outsourced employer will take the burdens of Canadian employment, payroll, group benefits, and human resource management of employees off your hands so you can focus on your business. An outsourced employer handles all aspects of employment from beginning to end. This reduces liabilities like those IC misclassifications and eliminates the potential penalties for filing taxation incorrectly. HR Options can employ Canadians doing work for U.S. companies or U.S. employees coming to work in Canada. We also have an office in the U.S. to provide third-party employment services to Canadian companies looking to employ there. If you're not already set up in Canada as an entity, hopefully these options give you some insight into the possibilities of coming to Canada. And that concludes our talking portion of today's webinar, and I thank you very much for joining us. We've put together a little reference page for you of agencies or vendors who can assist you. And now I'll turn things back over to Nunzio for our question and answer period. Nunzio?
Thank you, Stacy and Kathryn, for all this information. It was great. Let's jump into some questions that have come in throughout the presentation. First question is, and I guess I'll address this to Kathryn. Do we lose the non-resident status if we employ workers directly and do not employ them through an outsourced employer? Is that part of the criteria to get the tax exemption?
That's a really good question. You're not allowed to have an office or location in Canada. If those employees are working from home, you would have to check with a tax expert to see if that home office would be considered a location, to a permanent establishment. So there may be a window there where you might be able to be considered a non-resident, but the key question there would be what the permanent establishment would be considered. So I would definitely recommend talking to an accountant or a tax expert on that one. I don't feel comfortable saying one way or other. Sorry about that.
That's great. I'll go to Stacy for the next one. Do employers have to pay for employees' benefit coverage for employees on leave, or can we ask employees to pay for their benefit costs during their leave?
You can ask for employees to pay for their benefit coverage during their leave, which is quite common. A lot of employers do it. But what you want to do in a case like this is make sure that you have something either written in your contract that makes the employee aware that will happen when they go on a leave, or else at least in your handbook, so that you have something to go back to the employee and say, at the outset of employment, if you do go on a leave, so you know ahead of time that you're going to be responsible for the cost of the premium while you're on leave. So yes, it's quite possible for you to do that. In the case of someone on a maternity leave or along those lines, if you're paying a portion of those benefits for that employee, generally you'll have to double check with which province you're dealing with, but generally you have to continue your portion of the benefits while they're continuing their portion throughout the leave, unless they choose otherwise.
Perfect. Thanks, Stacy. Next one's for Kathryn. If our company uses an outsourced employer for our Canadian employees, are we considered co-employers like the PEOs in the U.S.? Sorry,
like the
PEOs in the U.S.
I know.
Sorry about
the Professional Employer Organization. That's a really good question. We get asked that all the time. And no, if HR Options is the employer of record in Canada, we are not a co-employer. We take on full liability and full responsibility for all tax remittance, for all workers' compensation coverage, for issuing the T4 and relevé at year-end, issuing records of employment, etc. So unlike a PEO, or a PEO you are co-employed, so usually a lot of times you might have to have your own workers' comp, and they'll remit the taxes. You might have to handle any employee relations issues that come up, or health and safety training as a co-employer. With HR Options being a fully outsourced employer of record, we do all the HR support, take on all the HR liability, as well as covering all the workers' comp and tax. So that answers the question.
Sounds good to me, Kathryn. Thank you. Next one for Stacy here.
Yeah.
Is eligibility for leave calendar or work week?
is eligibility for leave calendar or work week? I mean, you really have to, depending on what leave you're talking about, whether it's pregnancy leave or whether you're talking about compassionate care, it all really comes down to the particular province that your employee is employed in and the stipulations around that particular leave. So, for instance, sometimes it's not really by calendar year, but number of weeks of employment. So to be eligible, they have to have had worked, 13 weeks of employment or 52 weeks of employment, which goes outside of any sort of calendar date, if that makes sense. Hopefully it does. And if it doesn't, call us.
Yeah, I think for a regular person working Monday to Friday, 40-hour week, it's referring to that work week. And then if you have someone who's working a shift schedule, like in retail where they're working weekends, then you're prorating, you're creating the weeks yourself by dividing out the hours that they're working. So that can get a little bit more complicated. But in terms of, did they work 13 weeks to get a maternity leave, for example, then if it's a regular 40-hour a week person, you would look at that regular work week, that 13, not including the weekends. I think that's what the question might have been. Do you include weekends? I'm not sure. Anyway, like Stacey said, reach out. We weren't able to answer that.
Perfect. Kathryn, we'll stay with you for this question here. In Ontario, is it normal to provide 5 paid days for bereavement leave?
That's another great question that we get asked a lot. And yes, it is. So the legislation doesn't actually legislate anything for bereavement leave. It doesn't speak to it at all. It leaves it up to employers. And we find that anywhere between 3 and 5 days is the norm, 5 probably being the most popular that we see, 3 probably being the minimum amount that we see. It's really rare that we see an employer who doesn't provide any bereavement leave.
And it's true, in Ontario there's no bereavement leave. There are some provinces that do stipulate 3 days of leave, and sometimes the province will even stipulate what family member has passed away or what person has passed away in relation to whether they qualify for those. But as a company, like Kathryn mentioned, outside of that, you can provide as many as you wish.
Stacey, next question is for you. Should a new contract be signed by the employee when there is a promotion or salary increase?
Absolutely. So we say it's smartest to update your contracts anytime there's any sort of major consideration. Like we said, if there's a change in title, raises of over 3% is general rule when you are issuing new contracts. And in the meantime, if you are having a raise that's smaller than that, even a letter of addendum just saying, the rest of this contract will stay the same, but we are going to, your salary is now going to be this, and have them acknowledge it and have them sign it so that you're keeping up-to-date records with every change of that employee's employment. I know it's an administrative hassle, but it's always better in the long run if it comes down to a court battle that you have that evidence behind you or that contract behind you.
Kathryn, next question is for you, and this looks like a good one. Does the Canadian government audit for independent contractors as much as the U.S. government? Is there enforcement on independent contractors versus employee classification?
I'm not in the U.S., so it's harder for me to answer that. I do know that it is enforced in Canada. Definitely, the liability is that you'll have to pay back taxes if it is enforced. I will say that probably the most common way that an employer gets caught for misclassifying an independent contractor may not necessarily be an audit from the CRA, but from employees turning the employer in. So even if it's not a disgruntled employee, it could be, we've had situations where it was like the spouse or a friend of an employee who thought they were being treated incorrectly, so reported the employer as having misclassified the employee. The danger also, of course, if you do have a disgruntled employee, is they will, of course, turn you in because they're going to want termination pay if you let them go. If you've misclassified them as an independent contractor, they're going to come back for those termination pays and past benefits. So it definitely is a risk. Stacey and I were just actually talking on this topic yesterday, and it's not a risk that you want to take on for sure.
Okay, perfect. So we have time for one more question, but I also want to ask everyone to please take a minute to complete the evaluation that's located on the menu doc. Our last question is for Stacey. Can you pay an employee for another day off if they work the holiday? Do you still pay the 1.5 times their hours worked on the holiday?
That's a very good question. Again, I always have to say this, but refer to what province you're working in, because that has could have a major impact on how you pay out a public holiday. But generally speaking, for Ontario, I'll just use that as an example. If the employee works on the public holiday, they agreed to work on the public holiday, they can also agree to a substitute day off, in which case you don't have to pay the premium pay for them working to that day. So they work 8 hours the public holiday, and then on public holiday, and then on their substitute day, they get paid their other 8 hours. If they work on the public holiday and don't take a substitute day, that's when you pay the premium pay as well as the 8-hour public holiday pay.
Perfect. Thank
That's
you, Stacey.
Ontario.
Yes, perfect. So we're out of time for today. Again, if you'd like to contact the speakers, please view their contact information on the side there. I also look forward to seeing you online at future webinars, and I hope you all have a great day.